with Representative Bud Hulsey, and he's got two very interesting pieces of legislation that he's brought this year. The first one is the Tennessee Property Rights Protection Act, HB 444. So what is the intent of this bill? A lot of people don't really understand their property rights, much less what needs to be done to protect their property rights. Yeah. So what's the deal? It deals with actually eminent domain. Under existing law, the way the verbiage is under existing laws is it uses the term blighted property. I'm sorry, that's the new bill that I'm running, but it's a blighted area. And what's happened is most people don't like eminent domain to begin with, where even for the public cause, somebody can take your property away from you, but they can for a public use. But also under this same law that Tennessee has right now is housing authorities or agencies like that under the existing law that says a blighted area, they could take, let's say, a neighborhood that's got 150 homes in it, and there's 3 homes in there that truly are blighted. They can take the whole area. They can take all 150. And that's been attempted. They attempted that down in Chattanooga with 2,500 homes under this blighted area thing, when there really was not all that many blighted homes in the total of the 2,500. So what this bill does is it says, no, it's blighted property. So that if you've got a housing neighborhood with 150 homes and there are 3 blighted houses that truly are blighted, then these housing organizations can go in there and specifically take those 3, but they can't take any of the rest of them under the old area type mentality. So it protects those people and their property rights. It defines what blighted is, and it really doesn't curb the housing projects or housing authorities from doing anything else. I mean, they can. The way the bill's written, they can purchase property. If they want that property, they can buy it. You can still use eminent domain for a public purpose, like a fire station or a police station or something like that, or bridges or roads. But you just can't take a whole area of property because you have a few blighted pieces of property within it. So that's what that bill does. And that was passed in subcommittee last week. Do you feel like this has enough support to make it through the legislature this year? I do. I think it'll fly. Like I say, most people are pretty sour on eminent domain issues anyway. Mm-hmm. So I think we'll be successful with it. I've been wrong before, and I've been fooled before, but I think the votes are there. By the way, I've got to tell, David Seals is the man who really worked on this property issue and eminent domain issue. That he is the one that did all the wording in the bill and really did all the work with this. So I'm just running it for him. So. Yes, David Seals, great. Yeah, he's good. But he's a good man. And then the other bill that I want to talk to you about is the Restoring State Sovereignty Through Nullification Act that you've, both of these bills, by the way, for those of you watching, are sponsored by Janice in the Senate. And so what is nullification? The nullification bill comes from the constitutional principles that the federal government did not create the states. The states created the federal government. And the issue is the created thing have more power than the creator? And most people who go to law school for the past 100 years have been taught that whatever the federal government does is the supreme law of the land. And in my opinion, nothing would be further from the truth. They almost have the idea that the 10th Amendment to the Constitution is in there, but you have to ask the court's permission to exercise it. Mm. And I don't think that you will find that the framers thought that way absolutely at all. If you look at when this first came up and Thomas Jefferson did the orders for the state of Virginia on an issue that Congress had done,
And he took the stand that if a law that Congress passes is unconstitutional on its face, then it's not law at all, and you ignore it or you nullify it. So this bill of nullification, it says it doesn't make the legislature nullify anything. It just says if you do nullify, here's 5 ways to do it, is all this bill does. But the fight has been, particularly with law school boys, that the state doesn't have a right to do that. And they'll say, the Supremacy Clause. Well, of course, the Supremacy Clause says that the Constitution of the United States is the supreme law of the land and laws pursuant to it. Doesn't mean that every law that Congress passes is the supreme law of the land. It has to be pursuant to the Constitution. In other words, it has to be constitutional itself, or it is not the supreme law of the land. But getting through, particularly with law school boys, the idea that a state has a right to do this, and I believe it goes further than that. I believe you have a duty to do it, to protect Tennessee people from federal tyranny. And if you want to see a good act of tyranny, look at the last COVID issue when Biden came out with an executive order, which is another thing. Most people think that executive orders are law. Well, no, they're not. They're only supposed to be for the executive branch of government. If they apply to the people, then it's law, and the executive branch can't make law. But you saw that kind of tyranny come out when Biden says to all the employers in the state of Tennessee, you're going to force all your employees to take this shot, whether they want it or not. Well, right here in this legislature, the Speaker of the House and Lieutenant Governor ran a resolution that said to Biden, if you proceed down this road, we not only have a constitutional right to nullify what you said, but we will do so. And 64 members of the House voted for that resolution. So nullification is not a new thing. When the Fugitive Slave Act was passed, like in 1850, there were 12 states that nullified that and said to the federal government, that ain't happening here. Michigan went so far as to say, it ain't happening here, and if you try to do it and send an agent in here, you will go to jail for 5 years in this state. So, like I say, it's not new. You got about 30 or 40 different federal laws that deal with marijuana already on the books. And about 22 states in one form or another has said to the federal government, no, sorry, we're not doing that here. Mm-hmm. This is what we're doing. And they nullified it. When the Real ID was postulated 16, 17 years ago, I think 12 or 13 states at that time said, if you try to proceed with this, we'll nullify that. Of course, it just took 18 years of the federal government buying off your legislatures to the place that they wouldn't do it. But again, to me, constitutionally, and you read the old boys, the founders and the framers of this country, they would have never had a suggestion that the federal government has more authority than the state has. Now, does the federal government have authority? They do in the venues that the Constitution gives them. In fact, that's what Article 1, Section 8 of the United States Constitution says. It says the federal government actually has a right to mess around in about 18 things. And Article 1, Section 8 lists those 18 things. Absolutely everything else is left up to the power of the people of the states. So I try to tell people the federal government was carved out by the founders a little small garden. And the founders said, you can hoe in this garden. All the rest of this out here belongs to us. You hoe in your garden, and we'll hoe in ours. But over the last 100+ years, the federal government has slowly encroached in our garden and have been hoeing in our garden. So when Congress or the president, even the Supreme Court, can issue something that has an appearance of law, but it is not one of those 18 things, then it is unconstitutional on its face because they're out of their lanes constitutionally.
This has been a bill that has come through the legislature. What, this is the 4th year in a row or something like that?
This will be the third, yeah.
The 3rd year in a row. Why hasn't it passed before?
Well, the first time I ran it, it failed in the Senate. Last year when I ran it, the Senate sent it to summer study. I had already gotten it to the first committee and was lined up to go to the second, but it failed. It got sent to summer study in the Senate, so there's no sense in me running it on past that at that point. What I'm hoping, and it was a good summer study. They did give it to the chairman of that committee. To his credit, he honored what he said, and they did have a legitimate summer study on it, and it was good. I'm hoping with what came out of that summer study that people, at least who keep up with it, would understand, the state does have a right to do this, and the state has a duty to do this. And so this is a good thing. And like I said, the bill doesn't force the legislature to nullify anything. It just says, if you do it, here's 5 ways to do it.
Just setting up a process.
That's all it is. That's all it is.
Perfect.
But this process happens to marry up the people right next to the legislature, which I think is a win-win across the board. Because now the people can say, yeah, you're going to look at this, you're going to address it, and you're going to vote on it. Mm-hmm. You don't have to vote the way we want you to, but you're going to have to vote. Mm-hmm. I think that's a win-win deal.